Hey guys, welcome to our video. This is John Watts. I appreciate you taking the time to watch this video. I think you'll find it interesting if you are interested in the Fair Credit Reporting Act, and if you're interested in how that works with a bankruptcy when you have some debts that are discharged, but yet they are still reporting as a balance. And how does that, what's the interplay or interaction between the Fair Credit Reporting Act and the bankruptcy laws? So this is a case from a number of years ago, but still a good case, called Folks versus Equifax, and Middle District of Alabama, 2013. And so we start off, and the judge says, we have an entire statutory scheme devoted to protecting people's credit reports against inaccuracies. And that's important. That is what the Fair Credit Reporting Act is. It is to protect your credit reports against having any inaccuracies. And so we have, let me drop down here to the factual background. So these people filed bankruptcy in 2006. Evidently, they did what's called a Chapter 13, where you make payments over 5 years. And so they do that. Bankruptcy judge discharged their debts, including a debt owed to defendant Alabama Teleco Credit Union. And I'll say this, credit unions are great to deal with until they're not. And then they are some of the most difficult, aggressive, just sort of bloodthirsty entities out there. I mean, it's pretty bad when you can sort of make Bank of America or Wells Fargo look good. Now, again, they're great as long as you never get behind. But if they think you're behind, they just are almost unbearable to deal with. And we'll see in this example. So September 2011, and the consumers were ready for a fresh start, but their credit report was stuck in the past. Okay, Judge, how was it stuck in the past? Equifax, the credit reporting agency, continued to report an outstanding balance on their debt to Alabama Telco. Now, that debt had been discharged. And so the consumers complain about it. Equifax checks with Alabama Telco. Alabama Telco assured Equifax the information was accurate. Again and again, the consumer tried to correct the inaccuracy. Each time she met the same result. So credit report remained uncorrected. And notice the judge points out, here's the effect of that. Because oftentimes, let me put it to you this way, whenever we've sued the credit bureaus, whenever we've sued furnishers of information, so like Alabama Telco is a furnisher, they provide information, furnish information to the credit bureaus. Whenever we sue them, every single time, I mean, I'm talking, I can't even tell you how many lawsuits we filed over the last 20 years on this. Every single time the lawyer goes, well, John, it doesn't look like we did anything wrong. And even if we did, you weren't damaged by it. Now, we could put in there, we lost our security clearance. We missed out on mortgages. We got turned down for jobs. Always the same answer. Oh, it couldn't possibly have bothered you. Well, notice what the judge said. Inaccuracy had a profound effect. They suffered humiliation and embarrassment. They grew fearful, anxious, frustrated. They were angry, upset, emotionally distressed. They experienced other negative emotions. So they sue these defendants. And Alabama Telco is the one that is trying to throw the case out. So why are they trying to throw it out? Two reasons. Number one, it's barred by the language of the Fair Credit Reporting Act. In other words, you can't even sue us under the Fair Credit Reporting Act. I mean, Alabama Telco has made this fantastic discovery that they can provide false information. You can go to the credit bureaus, dispute it. The credit bureaus go to the furnisher, Alabama Telco, and Alabama Telco can say, we know it's wrong, but we're still going to keep it. And their argument is there's not one thing in the world you can do about that. That is a very, very typical argument from people who will trash your credit reports and refuse to fix it. So very typical. And they say, oh, by the way, since really the debt was discharged in bankruptcy and you don't owe it anymore, we can't collect it anymore, you can only sue us in bankruptcy court for doing false credit reporting. You can't use, what would the judge say, this entire statutory scheme to protect you from inaccuracies, the Fair Credit Reporting Act. This furnisher goes, you can't even use that. You can only use the bankruptcy code. So, court says, well, look, under 15 U.S.C. section 1681 S2A, there's nothing you can do about it. Everybody agrees with that. And this is part of what these furnishers do. They will put up this false argument. They'll say, well, we've been sued for false credit reporting, but we've figured out there's no cause of action. You can't sue us under Section 1681 S2A. Well, we never sue them under that. But they put up that false argument to say, well, since you can't sue us under there, you can't sue us under anything. And the judge says, but as the folks point out, they did not sue Alabama Telco for breaching its duty of accurate reporting. Instead, they stand accused of failing to properly investigate reports of inaccuracies. And that's after the credit bureau notifies the furnisher. And this is 1681 S2B. So it's really close. 1681 S2A, you can't do anything about. S2B, you absolutely can do something about it. And the 11th Circuit pointed this out in 2008. FCRA does provide a private right of action for violation of 1681 S2B. So think about this. Here's a case in 2013, and this credit union is coming into court going, you can't sue us under Fair Credit Reporting Act. There is no cause of action for that. Even though 5 years before, our appellate court, the 11th Circuit, which is over Alabama, Georgia, Florida, said, of course you can sue on that. Very typical of the way these companies act. Now, look at this next argument. Next, they say, you're precluded by Section 524 of the Bankruptcy Code, which prevents or enjoins creditors from attempting to collect discharged debts. They go, hey, we know we're trying to collect a discharged debt. We violated the Bankruptcy Code, not the Fair Credit Reporting Act. You can't sue under the Fair Credit Reporting Act. I mean, now we admit that there is the right to sue under the Fair Credit Reporting Act, but not here because we violated the bankruptcy court. And so they cite this sort of infamous case from the 9th Circuit called Walls versus Wells Fargo that said, if you sue for a discharge violation, so a debt collector's out there trying to collect a debt that's been discharged, if you sue under the FDCPA, Fair Debt Collection Practices Act, that is no good. You can only sue under bankruptcy law. Now, very few courts support this view, but this judge in Alabama says, but as it applies to the FCRA, 11th Circuit has never endorsed this rationale. The 7th Circuit rejected it. And then it says, to the best of this court's knowledge, no court has ever held the Bankruptcy Code conflicts with the FCRA so that one takes priority over the other. And so again, you have this credit union going, nobody can sue us under Fair Credit Reporting Act. And then the judge points out, this has long been the law. You can be sued. They go, oh, okay. Because we violated the bankruptcy law, you can't sue us under the Fair Credit Reporting Act. Only the bankruptcy law. And the judge is saying, no judge has ever said that. Again, these are the ridiculous arguments that we see made. And so they say when two statutes capable of coexistence, duty of the courts, absent a clearly expressed congressional intention to the contrary, to regard each as effective. Now the judge does say, I'm getting rid of the state law claims. Those are preempted under the FCRA. But I want to point this out, this footnote. So the lawyer that brought this case is a lawyer, his last name is Metcalf. And the judge, it's a little bit small, but hopefully you can see it on your screen. This is footnote 2. A contrary ruling, in other words, a ruling that says you can only go to bankruptcy court, you cannot sue under the Fair Credit Reporting Act. It says contrary ruling would put Mr. Metcalf, the folks' counsel, in a pickle. Well, why is that? Several years ago, he represented a different client against creditors who continued reporting a debt discharge in bankruptcy. It's called the Norman case. And this is back 2006. In that case, Mr. Metcalf took the approach Alabama telcos suggest and treated the creditor's conduct as a violation of the bankruptcy section 524. That's that discharge. Although Judge Sawyer in that case entertained the challenge, he was troubled that the debtor had, quote, resorted in the first instance, end quote, to the bankruptcy court and not first, quote, availed himself of remedies under the Fair Credit Reporting Act, end quote. Said Mr. Metcalf took the hint, and he now proceeds exactly as Judge Sawyer suggested. The folks are availing themselves of remedies under the Fair Credit Reporting Act instead of resorting to the bankruptcy court in the first instance. And the reason I bring this up is when judges kind of make suggestions like that, like this is what you really should do, they kind of expect you to follow it. And you're generally not going to be criticized or punished for following it. So here the lawyer had this identical situation back in '06, goes to bankruptcy court. The judge says, look, you really should have disputed under the Fair Credit Reporting Act, and you should sue under the Fair Credit Reporting Act. So 7 years later, he's in this situation. Guess what he does? He disputes under Fair Credit Reporting Act. He sues under Fair Credit Reporting Act. And this credit union goes, aha, you should have gone to bankruptcy court. The judge's like, no, 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 no. We've already announced this 7 years ago. This is the way you're supposed to do it. So again, it just shows that you do need to know the case law in your area to know what judges want, because it can vary from area to area. And so I wanted you to see this case for that reason, but also just to see, again, just the crazy arguments that these furnishers make when you catch them breaking the law. And we used to file a lot of these lawsuits over discharged debt. I haven't done much of this lately, and I frankly am not sure how common this is. So I'll probably put up a video just asking people, and so if you're listening to this, then I'm asking you, if you've had a discharge, or if you're a lawyer or a credit repair place and you deal with people who have bankruptcy discharges, are you seeing balances after the discharge on discharge debt? But I'll probably do a separate video on this as well. So anyway, thanks for watching this, and hope you found it helpful, and I'll catch you guys in the next video. Okay, take care. Bye-bye.